Hello students. In our modern business law class, in our previous video, we have discussed first subunit of first unit. That is, we have completed meaning, definitions and essentials of contract, and we have discussed classification of contracts. Now we are going to deal with second subunit of first unit, that is meaning and essentials of offer and acceptance. So from here, we are going to talk about all those 10 essentials of a valid contract in detail. So there are these 10 essentials of contract and one small unit, small topic we have to study on that particular point. So now we are going to talk about second subunit of first unit, that is meaning and essentials of offer and acceptance. First essential of a valid contract is agreement. How agreement is created? Agreement is created by way of an offer and acceptance. So from that now we are going to discuss about the offer. Offer is also known as proposal. So it is said that offer is the starting point of every contract. So it is the first step or it is the starting point in the process of concluding an agreement between the parties. So whenever an agreement or whenever a contract is to be created, first what should be there? There should be first element should be the offer. One person should give an offer to another person and that offer should be accepted, then it will become an agreement between the parties. Now how offer is to be created and what are the essentials of a valid offer, we are going to discuss this in this subunit. Now we will discuss the definition of offer. We will discuss the definition given by section 2A of Indian Contract Act. What is a proposal or what is an offer? So when one person signifies to another his willingness to do or abstain from doing anything. That means when one person in offer, when one person, what he is doing, he is signifying, he is showing his willingness to do something or not to do something. So when one person is signifies to another his willingness to do or abstain from doing means not doing something. Why he is doing signifying his willingness? Why? With a view to obtaining the assent of that other person to such an act or abstinence. Why he is signifying his willingness? To get the assent of that other person to such act means doing something or abstinence means not doing something. Then he is said to make a proposal. When one person signifies to another his willingness to do or abstain from doing anything. Why? With a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. So this is the definition of offer or proposal. Sometimes it is asked for 2 marks definition or this full question is asked for 15 marks. Define offer and what are the essentials of a valid offer. Now, the person who is making an offer or proposal, that person is called as the offerer or proposer. The person to whom the offer or proposal is made, that person is called as offeree or promisee. Example, A says to B that I am willing to sell my car to you for 2 lakh rupees. Here A is offeree and B is offerer. Sorry, A is offerer and B is offeree. Offerer is the person who is giving an offer. A is giving an offer, he is offerer and B is offeree. Yes. Now we are going to discuss essential elements of a valid contract. So there are 9 points which we have to discuss under this heading. First thing is, an offer must be made with an intention to create legal relations. Offer must be certain, definite and not vague. Offer must be expressed or implied. An offer may be specific or general. Offer must be distinguished from an invitation to offer. Offer must be communicated. Offer must be made with the view to obtain the consent of the offeree. Offer may be conditional, and no term, the non-compliance of which amounts to acceptance. So these are the 9 essentials of valid offer. So we have to discuss all these points in detail one by one. First point is, an offer must be made with an intention to create legal relations. Now we have already discussed this point in essentials of a valid contract. So if an offer does not intend to create legal relations, it is not a valid offer in the eyes of law. So as per law, whenever offer is given, that offer should be given with an intention to create legal relations. If there is no such intention, it is not a valid offer. What is an example of that? So when an offer is given by husband to his wife to show her a movie or to purchase a gift for wife, such offer is no offer because there is no intention to create legal relations. Another example, an offer to a friend to dine at offerer's place. So we have already discussed these 2 points. Again, say for example, one friend A invites B to attend marriage party. So due to rush, food was not allowed, food was not available. So in this case, even though there is offer, it is not a valid offer because there is no intention to create legal relations. So the person who could not get the food in marriage party, he will not have any right to file a case against the person who has invited him for the marriage. So when an offer is given, there must be an intention to create legal relations. Otherwise, it will not be a valid offer. Another example of it is, father promised his son, father said to his son that if in this exam you score above 90 percentage, I will give you a bike. As a gift, I will gift you a bike. So this was an offer which was given by father. So as per that offer, son studied very hard and he scored 92 percentage in the exam. So after that, son goes to father and says that as per your offer, and as per your promise, I have studied hard and scored 92%. Now, give me a bike. Father refuses to give. Can son has any remedy or any relief in the court of law? Can he go and file a case against father? There was an offer given by my father. I had accepted that offer. There was an agreement between us, and now father is not giving bike to me, and court should order my father to give a bike to me. No, because when father gave an offer, there was no intention to create legal relations. So it was offer was given or something was told out of domestic or social relationship, it will not lead to legal relations. So on this point, often a case study is asked. We have discussed a famous case study on this point, that is Balfour versus Balfour. Now, second point, offer must be certain, definite and not vague. So whenever any terms which are used in the offer, those terms should be certain terms. Words which are used should be certain, definite and no vague words should be used in the offer. Now what does it mean by vague? Vague means those words which are not clearly defined or which are not clearly understood or expressed words. So such words should not be used in the offer. If the terms which are used in an offer are vague terms, not clear or not clearly understood, or those words are indefinite, definite means those are unclear words, unclear terms are used in the offer, then its acceptance cannot create any contractual relationship. So in order that there should be a valid agreement or valid contract, it is necessary that the terms which are used in the offer should be clear, definite and no vague terms should be used in the contract. So here is an example of it. A offers to sell B. A gives an offer to B, says that I will sell you 100 quintals of oil. So in this case, this offer will not lead to a valid contract. Why? Because there is nothing to show. They have not mentioned anything about the kind of oil which was intended to be sold. Therefore, this offer is not certain offer. It will not lead to any contract between the parties. Another example of this, A offered to sell his car to B. A says that I am ready to sell my car to you for 2 lakh rupees or 2,50,000 rupees. Here, offer is not certain, uncertain. Whether he wants to sell it for 2 lakh or 2,50,000 rupees, it is not certain, it is not clear. Therefore, this which of the two prices were intended, it is not clear. Therefore, it will not lead to a valid contract between the parties. There is no valid offer and valid acceptance of that offer. Third point is offer must be expressed or implied. So already we have discussed what does it mean by expressed contract and implied contract. Expressed means when offer is given by words, either spoken words or written words, it is called as expressed offer. In case of implied offer, when an offer is not given by using words, either spoken or written, but offer is inferred from the conduct of a person or from the circumstances of the case, such offer is called as implied offer. So offer can be either expressed offer or implied offer. Thank you.